Good, good afternoon, ladies and gentlemen. I am Tiwalola Osezua, partner in the Corporate Commercial and Mergers Acquisitions team at AELEX, and I will be coordinating our conversation today on collateral structuring, some key legal considerations. Before we move forward, I would like to inform the participants to feel free to have conversations in the chat box as the speakers respond to some of the issues that we'll be discussing today. Also, feel free to drop your questions in the Q&A box, and the speakers will get to answering them at some point in the course of today's session. Now, before diving into our conversation proper, I would like to briefly state the key objectives of this chat series. One of it is for it to be a learning and discussion platform for legal and commercial issues that impact transactions in the financial sector. The second is to be able to offer detailed and objective analysis of emerging and new developments in the financial sector. So the first question is, what is a collateral? A collateral is essentially something that is pledged as security for repayment of a loan, and that can be forfeited in the event of default. To a lender, a collateral has to be a valuable asset that it will consider security enough to grant the loan. Now, prior to the Banks and Other Financial Institutions Act of 2020, banks were able to grant unsecured loans, provided that those were done according to their internal policies. However, by virtue of Section 19(1) of the BOFIA of 2020, banks can only now do so, provided they've obtained the approval of the CBN. Now, what CBN has essentially done is to set, kind of raise the bar or the standard in relation to banks giving unsecured loans, right? Now, when you look at that page and you also consider the failed banks and fraudulent financial malpractices, you would notice that there are now, personal and institutional risks that attach to financial institutions and their officers. So what should banks, be thinking about in granting loans? First point will be for them to abstain, if possible, from granting unsecured loans. Second would be if you're granting an unsecured loan, then you need to ensure that you've obtained the appropriate approval or waiver from the Central Bank of Nigeria. And you must also ensure that whatever collateral that is being given or accepted by them is adequate, non-defective, and traceable. Now, clearly, adequate or non-defective security can be achieved if you structure your collaterals properly. And that is why we're having this conversation today. And so to move the conversation ahead, I have with me today two experts who will assist with the conversation. And that is Mrs. Abiola Baruwa and Mr. Shino Sipasi. Abiola is currently the company secretary of Rand Merchant Bank, Nigeria Limited. She commenced her career as a practicing lawyer in one of the leading firms in Nigeria in 2004. She moved into the finance sector in 2008 and worked on structured finance transactions in diverse sectors, including oil and gas, power, and telecommunications at Sky Bank and ABN Quest Merchant Bank. Abiola led the corporate banking legal team in EcoBank Nigeria and also held the role of head of company secretariat. She graduated cum laude from Lagos State University and the Nigerian Law School, Abuja. She holds a master's in international finance law from prestigious King's College London, UK, and she's a member of the Institute of Chartered Secretaries of Nigeria and the Institute of Directors. You're welcome, Abiola.
Thank you very much, Tiwa.
Shino Sipasi is a partner in the banking and finance and energy practice groups at AELEX. He has over 2 decades of experience advising lenders, corporate borrowers, and governmental organizations on banking and finance, capital markets, restructuring, project finance, and development transactions. He is a seasoned expert, recognized by various legal directories for his exceptional work in the finance and energy space. He is currently ranked as a 2022 national leader in energy, natural resources, mining, and project finance by Usman Legal. So let's get into our conversation this afternoon. Abiola, I will start with you. Now, given the statutory requirement that collaterals must be adequate, non-defective, and traceable, what pre-commitment steps do lenders take in order to ensure that collaterals meet qualitative requirements? So for instance, what sort of due diligence do you see, and what constraints do you think financial institutions encounter due to the CBN's current posture?
Okay, thank you, Tiwa, for that question. So essentially, what banks do before taking collateral is commercial due diligence on the borrower and also on the transaction itself. And when they find that they will be taking assets as collateral, that it's essential that tangible assets are taken as security, what the banks would then do is to carry out extensive due diligence on those assets. You want to be sure that they're not encumbered. And then the legal documentation in which you'll be using to take on those assets as collateral must be enforceable. That banks would ensure that this is done. And they will also ensure that all necessary perfection is done on those assets, because you want to be sure that at the time you want to, in the event of enforcement, you're able to realize your security. But I want to say something, Tiwa, reacting to that that provision that says security collateral must be adequate. The reality is that what is adequate? It's a subjective and a relative word. What we find is that what is adequate for the banks may not be for the regulator. And from experience, what we find is that when certain banks with certain type of licenses lend to big, huge corporates that have huge cash flows, you've done your analysis, you've done your credit analysis, and you've seen that the credit risk are sort of very minimal. And so you can afford to accept a negative pledge, for example, as security. And then usually these big corporates with huge cash flows have a lot of banks at their beck and call. They usually they actually take financing in the form of syndications, lots of lenders coming together to give them loans. You as a bank can't be an outlier to say, I will be taking tangible security when others are taking negative pledge, especially because you've looked at the credit analysis, is the credit risk from that borrower is very, very low. Secondly, all banks in Nigeria have an obligation of 65% LDR, loan to deposit ratio, to the CBN. What that essentially means is that for every 100 Naira deposit you have as a bank, 65 Naira of it must be going to lending. You don't want to lose business with those sort of corporates, huge corporates. You don't want to be paying fines to your regulators that you've not met your LDR 65% ratio. So you would take on some of these facilities because you have done your credit risk and the credit, you've done your credit analysis, and the credit risk is very, very minimal. But when the regulators come and they see those sort of security or collateral, in their view, it's not adequate. You should have taken more assets. You should have taken bigger and tangible security. So I think the message here is that when looking at the adequacy of collateral, a lot of factors must be considered. You must look at the license of the bank that is taking that security. What sort of license has it got? You must look at the nature of the transaction itself. And you must also look at the credit risk of the borrower, when considering these things. Thank you.
Thanks a lot for that response, Abiola. And I think that brings me in, to my next question. So, I mean, people take loans for different reasons, right? Corporations take loans for different reasons. So it could be for a pre-export loan, it could be to finance an infrastructure project or commodity trading and whatnot. So what, in your view, are the types of collaterals that banks seem to prefer? I imagine it may differ depending on what it is, the loan is to be used for, but I would like you to just speak a bit on what sort of collaterals banks seem to prefer.
Okay, so a number, like I said, a number of factors are looked at when you're deciding on the type of collateral that the bank would prefer. You would want to look at even the type of facility or type of transaction that you're considering. You want to look at the credit risk that are all entrenched in the transaction, and then it then forms the sort of collateral that you'll be taking on the particular transaction. But top of my head now, in terms of not looking at maybe delving into the credit risk, for certain types of transaction or financing, the expectations on the sort of security you would even be taking in the first place. So for example, for asset acquisition financing, the banks would typically want to look at that particular asset that they're financing to want to take collateral over it, maybe in form of a charge. If it's a property, they want to take a form of legal mortgage, over that property. If it's capex financing, that is financing you give companies to expand their business, then you want to look at an all asset debenture. You want to take an all asset debenture, over the assets of that company at the very minimum. If it's OPEX financing, where you're financing the operations of the company, you want to look at the cash flows. In terms of domiciling the cash flows, you want to look at taking the charge over the revenues accounts, of that company. So these are the sort of, and these are very, like I said, these are the basics. But when the credit risk are now analyzed, there may be additional collateral that may be taken, because of other risks that we haven't identified.
I think an interesting point that has been made, and I think that we need to look at that both lenders and borrowers need to look at and probably explore some more is the point that really, when we say security, the word of collateral, the word really can be very fluid. And an interesting point that Abiola has made is the fact that it could even be a negative pledge. That's really very interesting. So here's the regulator coming and checking the books, and then the lender is saying, well, there's actually security. There's a negative pledge because I could see that they have this particular type of asset. I know that that asset is more than enough to, get my loan paid, the revenue coming from it. And I've ensured that nothing can happen to that asset, so that no matter what happens, I will always have, that first leaders, that first right to exercise lien over the asset. So I think that's a very interesting consideration that parties need to look at when they're looking at security, because just like she said, it introduces a lot of flexibility and structuring opportunities for banks.
Thank you for that, Shino, and thank you, Abiola. And I think we're going to talk a bit more now about, specific, or typical collaterals that we'll see. And one of them is share charge. It's one of the key collaterals usually required by banks. However, Section 22 of the BOFIA now requires banks to obtain CBN's consent before they can enforce security over those shares. What do you think, Shino, necessitates this requirement?
Yeah, so just by way of setting a scene for that, the share charge is one of the most popular securities in major transactions, whether it is a project finance transaction, where you're using an SPV structure, or whatever, whether it is an acquisition finance transaction, any major transactions that requires lending money to a corporation. One of the security that lenders will look at will be the share charge. And I must say straight ahead that when lenders are looking at share charges, their strategy is not that. The driving strategy is not to acquire and control the company. That's not the driving strategy. The strategy basically is to make it possible for them to enable a third party that can run that business to take over that company. So the plan is never for the bank to take over the business of a steel manufacturer, for instance. that is not the core duty of a bank. Now, coming back to that provision of Section 22, Section 22 does not prevent the recovery of the shares in an enforcement situation. What it does prevent is to prevent a bank from holding on to those shares in the event of enforcement. So looking at Section 22 straight off, we can say that a bank, if it becomes extremely necessary, can recover the shares and then almost immediately sell it off. That bank, transfer the share to a third party. That bank in that instance will not have breached Section 22. But what CBN is seeking to prevent under Section 22 is a situation where banks are holding on to shares that could have the possibility of distracting the bank from its core banking operation, and secondly, that could have the possibility of watering down or affecting the capital adequacy ratio for the bank. The CBN doesn't want anything that will upset these, and they are very focused on ensuring that banks stay true to their original purpose.
Okay, got you. I mean,
I just want to add to,
yes,
I just want to react to what Shina's just said now. And the reason the CBN is very particular in terms of not allowing banks to hold on to shares that they have share charge over on, and then moving on to become shareholders in those companies where they've obtained a share charge over, is because of the nature of our license. We are in the business of accepting deposits from our customers and lending transactions. We are not in the business of being shareholders or being directors or shareholders in other companies with other endeavors. So that is the major reason why the CBN is very particular. Also, you don't want to be taking depositors' funds to be using as some form of cash call when you have cash calls in those companies, in terms of building or in terms of carrying out capital projects in those companies. So essentially, the CBN wants the banks to be focused on the permissible activities listed on their licenses.
Thank you, Abiola, for that. And I think that addition, is very, very helpful. And when Shina was also responding to the question, he did mention, he hinted at what I was going to ask next, which is around what practical steps, banks can then take, in view of the, sort of restrictions that they have under Section 20. And you had mentioned a key point, which is about that there's a difference between enforcement and actually retaining. So are there other practical steps that you want to talk about, or Shina, do you want to talk a bit more about what those practical steps could look like?
Okay, so this provision came up maybe as a result of experiences that experiences that banks have had, in the past, and ordinarily, people are looking at this from outside the country. They probably think, why do you need this particular provision? Because banks are not expected to want to retain those shares. But based on experiences that we've had in the country, I think CBN found it necessary to make that part of the law at this point. I mean, it was enacted as part of the law. But I think by way of practical point, when we're structuring share charges, there are a lot of steps already being taken to ensure that at least the lender is immediately protected in the event of enforcement. For every share charge, one of the key mechanisms that lenders and borrowers use to give effect to a share charge is the share transfer form. Share transfer form. It is a blank share transfer form that has already been approved and signed by the borrower. At the point at which that is being done, it will be undated. Sometimes you can even have an undated board resolution. I know that, well, the already executed bank transfer form and the already executed, the board resolution, preferably written resolution, do you understand, that had been obtained. I know that if directors change and so on and so forth, it can have some problems later. But these are like due diligence step. Do you understand? Proactive steps that are being taken to ensure that they are able to immediately give effect at the point of enforcement. Because really, at the point of enforcement, the borrower and lenders that were smiling when they were negotiating the transaction, at the point of enforcement, they're not smiling at each other at all. Sometimes all those documentation, suddenly all those documentation that are prepared during the loan transaction process become very, very, very important. So basically they will do that. And what that enables is for the bank does not even have to acquire the share for itself. They can just find a third party that is willing that is willing to acquire those shares, and put the name of the third party, and that's it. And that's it. So they can do that. But in the event that if in the heat of enforcement, it becomes necessary for the bank to put its name, right, and acquire those shares, what the bank just needs to understand is that the law still permits that. But what the law will frown at is that you can't hold on to it. So as soon as that is acquired, they need to move very quickly to ensure that those shares are transferred to a third party. Otherwise, they may have to go back to CBN to start looking for approval. And that may be a difficult mountain to climb.
Thank you for that. So let's move away from share charges, for a bit and talk a bit about petroleum assets. Now, the use of petroleum assets as collateral has been, a sore issue in the market for a while as to issues around unenforceability and things like that. But under the PIA now, specifically Section 955, it now allows petroleum assets to be used as collateral, provided the consent of the NUPRC is obtained for that. So do you think that the PIA has sufficiently addressed the concerns of lenders around, being able to create effective charges on petroleum assets? And that is for Abiola, sorry.
Okay, I was just wondering, okay. So I think the simple answer is yes, because in the past, under the former legislation, that's the Petroleum Act, once you create a charge over those petroleum assets, there is no way you can carry out any form of perfection. And because of that, there's no notification to any potential encompasser that you've actually taken a charge over those assets. But what Section 95, subsection 5 of the PIA has done is that once you have the consent of the Nigerian Upstream Petroleum Regulation Commission, once you have the commission's consent, what you've done is to obtain some form of perfection over the charge you create over those petroleum assets. And essentially, any potential encompasser now has notification that you have created a charge over those assets. So it is a welcome development, it's a good initiative of the PIA. And even though there are conceptions out there that, well, you still need ministerial consent, the reality is that ministerial consent would now come into play where you need to enforce, those sort of assets. But in terms of allowing and giving some form of comfort to lenders, the PIA, that section in the PIA has done a good job of providing an avenue for perfection and providing an avenue for notification to potential encompassers.
Yeah. So in addition to that, really, when people talk about security over petroleum assets in Nigeria, they make it look as though our situation is unique. But I'm now just thinking back. I realize that the situation is the same actually in most resource owing, in most countries where natural resources are owned by the state. I know that the situation is the same whenever we look at transactions in Ghana. In fact, I recall a transaction in Chad where basically your petroleum agreement is essentially an act of parliament. And there were always issues around how to create effective security around those type of assets. So I agree with Abiola, and I think we can give kudos to the government of Nigeria for taking this very interesting step to ensure that at least there's a way to validly create security over petroleum assets in Nigeria. We're hoping the same thing can be done with respect to the mining, because really this provision, I mean, the problem about creating security over a natural resource asset has been to some extent resolved when it comes to petroleum assets, but we still have mining assets in Nigeria. I mean, Nigeria has about 36 world-class deposit of different types of solid minerals. There's still no way of creating effective security over them. Prior to the PIA provision, what lawyers will argue is that the law that guides validity of security is CAMA. And as long as you have created your security in accordance with CAMA, that security is valid, right? But it was an arguable case until this point now, until this issue. And I do agree that, well, enforcement, when it comes to enforcement, there's no walking away from the consent of the minister. But I wonder what Abiola thinks in view of the new business
Facilitation Act.
Facilitation Act.
Yeah.
BF, yes. Okay, so I mean, with the new in view of the Business Facilitation Act, I think what that has done, I think I've gone through it, high level review, even in respect of obtaining ministerial consent. The problem used to be, how long will it come? How long will it take before we get it? I've seen a scenario where it took 2-3 years, but even in the PIA, if you look closely at the section on obtaining consent, that same section 95, and also in the BFA, the Business Facilitation Act, you will find there that you now have clauses like snooze or lose, sort of like deemed consent. So if we wait for 60 days, I think the one for ministerial consent is 60 days. If we wait for 60 days after the recommendation of the commission to the minister to say, approve this, and there is no sort of dissent or any form of notification or communication from the minister that he's not approving, then it can be deemed that that approval has been obtained. So I think that's also a good development under the PIA as well, which deals with the problem of elongation of obtaining ministerial consent.
So basically, we can say we have a huge. I mean, we're moving from a regime of, I mean, where things are very uncertain to a point, at least in the oil and gas sector, where there's certainty and predictability.
Exactly, and when I mean, one of the issues that we've always suffered in Nigeria, which is hampering direct foreign investment from offshore, is the problem of uncertainty. You can't have legislations that don't talk about certainty in terms of obtaining licenses and permits within reasonable time, and still expect people to pump in huge amounts of investment in them. So those are the sort of things that PBEC looked at in ensuring that, there's some form of certainty in terms of obtaining these licenses and permits.
Thank you, Shino and Abiola, for that. I think, we've talked a little bit about, the different share charges, petroleum assets. Shino mentioned a bit about, mining and all of that. We don't have so much time left, but in the short, time that we have, I'd like us to talk a bit about the provisions in CAMA on financial assistance. And so, Abiola, CAMA 2020 relaxed the provisions on financial assistance, or made some changes different from under the previous CAMA. So how do you think this has affected collateral structuring, especially in acquisition finance?
Okay, I think for when you even talk about financial assistance, you're talking about any form of assistance that a company provides to a purchaser of its shares, any form of finance that any company provides in purchasing its own shares, and so let me give an analogy. So Orange Limited is interested in obtaining 70 or 80% in Apple Limited, and Apple Limited now provides a loan to Orange Limited to say, come and purchase my shares. Or Apple Limited uses its own assets as some form of collateral in any share acquisition financing for Orange Limited to obtain those shares. That is financial assistance. And under the previous legislation, that's the CAMA 1990, that was prohibited outrightly. But coming under the CAMA 2020, what that has done is to say financial assistance is permitted as long as it's not up to 50% of the net assets of the target company. That's, for example, my analogy, that's Apple Limited now. So if the target, if you've not used up to 50% of the net assets of the target company, that is permissible. So that's what essentially CAMA 2020 has done, is to provide something we call permissible financial assistance. So by and large, I think it's a welcome development, because it has made share acquisition financing a lot easier, in terms of providing some form of collateral in that regard. The issue I see sometimes, I think the issue I just see is that where the permissible financial assistance from the target company is not sufficient, that is where you may have one or two more structurings, by investment banks and, banks coming to structure something together to make it work. And then the banks will look at other sort of collateral. Maybe they'll be looking at taking a share charge on the shares to be acquired itself. They'll be looking at even the dividends, from those shares that are being acquired, so that there could be some form of extra support in addition to that permissible financial assistance.
Yeah, so I agree with Abiola. The position we have right now under the law, under CAMA, is better than what it was, and it has moved us closer, really to global global practice. And I know in the past, advisors and IMLAs, people who arrange loans, have really used interesting structures, to deal with this issue of financial assistance, maybe through creating a different structure for the acquisition loan, and then creating a different structure for loans that the target itself can take. I think we've done a few. I'm sure you probably want to expand it a bit on it. That's because I know you've done it a lot.
Okay, so I just gave a high level. I mean, in terms of where, and I think what you're trying to talk about is a scenario where the permissible financial assistance is not sufficient, right? So in that scenario, what I've seen or experienced happen is the financing will now be structured as into two financings. You have the share acquisition financing itself, then you have the capex financing. And what the share acquisition financing will do is that it affords the lenders the opportunity to take the shares as a charge. They will have a charge over the shares, and they will also be able to take a charge over the dividends from those shares that have been acquired. Now, the CAPEX financing would allow, like I said earlier when I was talking about CAPEX financing, it would allow the banks to provide financing, because lenders are not oblivious of the fact that if it's only when you make profits that you can actually declare dividend, that the shares that you're actually financing will make sense. So it's important that we put some money into the company, the target company itself, so that it would increase its cash flows. And the only way you can do that is by providing capital expenditure financing to the target company. And when you put CAPEX financing into a company, what you have essentially done is allow cash flows of that company to increase. And when you allow cash flows of the company to increase, you allow more monies to be declared as dividend, and you as a lender can actually be repaid. Now, the other thing CAPEX financing does is to allow you to, I've seen a messy situation whereby lenders have the shares of a target company, they don't have the assets. So two separate scenarios, where a set of lenders have security over the assets, another set of lenders have security over the shares. You don't want that sort of transaction, particularly when unfortunately it leads to enforcement. That would be messy. So most of the time, when you're given a share acquisition financing, you want to be sure that at least there's some little amount of money going into the target company itself to improve that company, essentially its cash flows, and you'll be able to guarantee your repayments.
That has been quite enlightening, especially as Shino made you speak a bit more about, the sort of, ways you've tried to work around that. So, I mean, Shino, would you say that, just thinking about the asset reduction benchmark under financial assistance that Abiola mentioned earlier. So would would financial assistance provided in the form of a guarantee or, be considered to reduce a company's net assets? And I'm hoping that you can respond to that in light of the IFRS provisions that categorize guarantees / securities.
Okay, so first of all, I will respond as a lawyer that comma provision is clear. It will not constitute financial assistance as long as it does not reduce the company's net asset by up to 50%. Now, that's what we know as lawyers, but I also understand that there are ways that accountants can look at it. Maybe having to deal with a question which is an accounting question, and also a legal question as to whether a security or a guarantee will constitute a liability for purposes of determining what net asset will be. The only thing I can say, or I would like to say at this point with respect to that, is that the new provision we have on financial assistance is not novel. It's not new. In fact, what the drafter of CAMA did was to lift a similar provision, word for word, from the UK Companies Act. And there has been authorities, there have been opinions under the UK Companies Act to the effect that if you look at, if you consider IFRS standard for determining what constitutes liability or not, I think a case could be made or it is arguable whether indeed a guarantee or a security will constitute liability for purposes of determining net assets. It's sounding very technical, but it's pretty straightforward. But it is something for people that, I mean, both for bankers and both for lenders and borrowers that will be structuring, especially acquisition transaction. It is a possibility, or it is something for them to look at and then speak to their advisors, and they're properly advised as to whether indeed a guarantee or a security given by the target company will be classed or may be classed as a liability for purposes of determining whether they reduce the net asset or not.
Great.
Can I react to
Yes,
what Shino just said now? I think that I appreciate the fact that CAMA 2020 has actually clarified what net assets mean, in terms of saying that is the difference between the aggregate assets and the aggregate liabilities of the company. But the advice is that when calculating and computing what actually net assets come to, it is advisable that the lawyers also sit with accounting experts, because of IFRS provisions, because of AIS provisions, so that you're not falling foul of that provision in CAMA.
Thank you for that, Abiola. And I think that's a good point. And I think that's what Shino was also saying when he said it's both an accounting issue and a legal issue. I've got a number of questions, but time is running out. But I'm just going to take this last question, and I'm going to direct it to you again, Shino. So it's about stamp duties. So recently, FRS posturing requires transacting parties to pay full stamp duties as against, the initial usual market practice, which was to understand, basically. So how do you think this has impacted on the market? Can you say anything? Because it's quite important when it comes to, collateral structuring.
So this effort really started during the COVID years, and when the federal government instituted a committee basically to look at back taxes, because I think FIRS recognized the fact that the normal practice whenever you're looking at a loan transaction is for parties to say that our loan is X, but we're going to stamp for a percentage of X. And what basically they're looking at is Section 82(1) of the Stamp Duties Act, which says that stamp duties should be paid on the amount recoverable. So basically, there's another provision that says that other provision that says that you should pay your stamp duty on the secured amount. So there are two ways of looking at it. The borrower will be happy and quite content to want to pay stamp duty on what they call the secured amount. And looking at the provision of CAMA, the secured amount, or where you can take advantage of priority, cannot exceed what you pay stamp duties on. And ordinarily, it works like that. But based on this recent posturing, and we've had clients who have raised this with us. They've had a situation where FIRS come knocking at their door, saying that for this your loan transaction, you paid 10%, but really the amount of the loan that you took was actually 10 times higher than so come and pay the remaining stamp duty. And we realize that where the FIRS is anchoring, the section that the FIRS is anchoring this argument on is that Section 81, subsection 1, that requires payment of stamp duty on the recoverable amount. So there's some good analysis we could have done on that, but time won't permit us. But at least it is something, again, for especially borrowers to look at, and also lenders, and keep in mind when they are structuring their collateral, because how much you pay as stamp duty is part of that collateral structuring issues that parties need to pay attention to. Thank you.
Thank you for that, Shino. So I want us to take some questions, and I see questions flooding in the Q&A box. We probably won't be able to take them all. Let me just go through that. So I have a question here.
Sorry, so I think there's one question that I can see the chat box myself. I think there's one question directed at me directly.
Okay. Yes.
Yeah.
The one from Alamin, right?
Yes. Do you want to read it out?
Okay. Yeah. So it says, how does the almost blanket restriction on unsecured loans affect the business of banks, such as merchant banks, when structuring loans for big corporations?
Okay, so no doubt. I mean, that was why when I was making that analogy in terms of what is adequate security, I was actually considering merchant banks, because merchant banks, by the nature of their license, lend to big, huge corporates with huge cash flows, and their credit risk, like I said, are very minimal. And so you can almost lend to them unsecured. Right. So, and like I said, we continue to enter into debates with the regulator when they come for their bank examination rounds, because in their own view, while we don't lend totally unsecured, we take something like a negative pledge, even in the view of the eyes of the regulator, that is not sufficient security. But it continues to, like I said, continues to be a debate. But it has not slowed down our business with these large corporates. It hasn't, because we'll rather enter into those debates and continue our dialogue with the regulator than go flouting our LDR obligation of 65% ratio obligation that we owe, because that again, you will be paying you'll be paying fines for them, and you also be reporting yourself in your financial reports. So you don't want to do that. You rather continue to have that dialogue with the regulator, and hopefully at some point, even and usually they calm down when they see that those loans are actually performing and there are no issues with those sort of loans, you know. So I think they're just trying to provide warnings that we warned you, you know, and all of that, but we continue to have continuous dialogue with them.
Thank you, Abiola. Thank you for that answer. We also have a question here directed to Shino as well. And it says that you mentioned that banks are not allowed to hold shares under BOFIA. What practical steps can a bank lender take to enforce a share charge without breaching the provisions of BOFIA? I think you did speak a bit on that, but maybe you can just very quickly answer Akintunde's question.
So the short answer to that is that the provision of BOFIA is really targeted at banks retaining those shares, not recovering them. So you can recover and transfer to a third party, but the essence is to prevent them from retaining those shares and just holding on to them as maybe one of the assets.
Okay, thank you for that quick answer. Let's see, maybe we can do another question. There's a question here on antitrust issues. And the question says, how do you deal with antitrust issues, approvals, especially when the company you want to transfer to is in the same line of business with the borrower when enforcing a share charge? I think this person is talking about whether or not you need to get the FCCPC approval for that. So I don't know, Abiola, Shino.
I guess they asked that question because they saw you and they know you do M&A. But really, I think this is something we can give to the appropriate experts within the firm to address. Yeah. Unless you want to address it now.
Yeah. On a general note, I mean, you know, there's certain triggers, you know, to FCCPC approval. So if what you're doing triggers that. So if there's an acquisition of control and the turnover threshold of the target entity, so that's the entity in which the share of the entity whose shares is being acquired, falls within that threshold. So either the target zone is the threshold is about 500 million naira in the preceding year, or you combined turnover of both parties involved is up to 1 billion, then you need to notify. But you will need to check whether those elements are present in order to really be able to determine whether or not antitrust approval will be triggered. I mean, I don't imagine that a bank actually executing the share transfer forms in its name, like Shina had mentioned before, should trigger need for FCCPC approval. I think that is all we can take. I see some of the questions here. And what I will say to the participants is that we will take these questions on. And if you have any additional questions, you can send them to bankingandfinance@aelex.com. Bankingandfinance@aelex.com. I'm hoping that our administrator will put that in the chat box so that you can copy that and then send us your emails, your questions, and the speakers will try their utmost best to send the answers across to you. This has been a very interesting conversation for me, and I'm sure that it's been for our participants as well. I don't know if Abiola or Shino have any last words they would like to say just before we wrap up.
Okay, not from me. I mean, I've thoroughly enjoyed this conversation. I mean, it's a good initiative from AELEX. I think you should keep it up. Thank you, Abiola. Shino?
Yeah, I guess the only other thing I want to add to some of the things you've said, Tiwa, is that I think this session is going to also be on the AELEX YouTube channel, and that people can always go back and have a look at it. And then, like you said, we do whatever we can to ensure that we respond to all the questions that we're not able to respond to.
Yeah, and our participants should look forward to, follow us on LinkedIn. You'll see notifications of subsequent chat series. Like I said, it's a series. So we're going to have a series of chats on different issues. Today, we talk about collateral, the different types, share charges, petroleum assets, what's changed, what's new, and we'll continue to do those. So I just want to thank our participants again for joining us. From start to finish, I see that we have lots of people, and thank you for your questions as well. And I'll just wish us all a good day and happy election weekend to all.
Thank you.
Bye.
Yeah.
Thanks.
Thank you so much.